Hello, today I'm here to discuss about some most important articles of our Indian Constitution. They will be very helpful for your upcoming examinations. So, let's start from Article 19. Under it, there are six democratic freedoms as fundamental rights unto the citizens which are very essential for healthy functioning of democracy. So, let's start from as right to freedom of speech and expressions. Under it, every citizen can express their views, opinions in the form of writing, printing, with respect to press freedom, advertisement, telecast, demonstrations, etc. But there are also some reasonable restrictions with respect to freedom of speech and expressions. They arise in a state security, friendly relations with other state, contempt of court, defamation, and incitement to any offences. So, if I ask one question, is freedom of speech and expression limited by boundaries of country? So, within respect to India, it will be no, but with respect to any other country, it is limited. So, it is not absolute right, rather, a reasonable restrictions will be there. Next is right to assemble peacefully, as it guarantees to assemble to all citizens. It means only for Indians, including the right to hold meeting and carry out procession in peaceful manner, but only on the public land. But there are also some reasonable restrictions with respect to right to assemble, as sovereignty and integrity of India, and to maintain public order and morality in the society. Next is right to farm association, as it guarantees to all citizens the right to farm association of any type, including right to farm cooperative society, which was added in Article 19, Clause 1, Subclause C through 97th Constitutional Amendment Act 2011. And this right also includes right to farm trade unions. However, right to farm trade union doesn't imply having a fundamental right to strike. Therefore, right to strike may be a legal right, but it is not a fundamental rights. So next is right to practice any profession, trade or union. Exceptions is immoral trafficking and indigenous things or occupations. There are also some reasonable restrictions as state can prescribe qualification needed for practicing a particular profession, trade, etc. And it can carry any business, particularly or completely or excluding citizens, but in respect of general public. So next is right to reside and settle in any part of India. With respect to reside and settlement, reside is considered as temporary, but settlement may be permanent. And next is right to move freely throughout the territory of India in interstate and intrastate. Interstate it means within the state, and intrastate it means out of the state you can move. But there are reasonable restrictions in respect to general public and in interest of scheduled tribes also. So Article 19 originally had seven rights, but right to acquire, hold, dispose of property was removed by 44th Constitutional Amendment Act 1978, and it was added to Article 300A. So before going to discuss Article 20, let's discuss some technical terms as legal person. Legal person may be human and non-human. Under non-human, it may be firm and government agency. It recognized to have legal rights like entering into contracts and etc. So let's discuss double jeopardy with an example. As a person commits a crime and goes for trial as within acquitted and convicted. So whatever the verdict is done, he can't be tried again for the same offense. And main idea is to prevent the state from trying the case again and again. In case of double jeopardy, in respect of India, double jeopardy is applicable only in case of conviction. Let's discuss about the ex post facto. Under it, law is created at present but applied to the past in civil law, not in criminal law. So next is Article 20, which is applicable for foreigner citizen. It means only for Indians and legal persons. The purpose was to protect against arbitrary and excessive punishment, as ex post facto law is applicable only for criminal laws, not applicable civil tax laws or preventive detention, and double jeopardy is applicable only for case of court or tribunal, but not in the form of departmental and administrative proceedings. And self incrimination is applicable only for criminal proceedings, not civil proceedings. So, before going to discuss Article 21, let's discuss some other things as procedure established by law. Under it, a law enacted is valid if it has followed the correct procedure for making the law, and it is mentioned in Indian Constitution. That is, procedure established by law is mentioned in Indian Constitution, but due process of law in respect of wide meaning will be procedure established by law, and the process should be fair, just, but not arbitrary, and due process of law was taken from USA. So next article is Article 21, protection of life and personal liberty, and it is considered as heart of the fundamental rights. So no person shall be deprived of his life or personal liberty except according to procedure established by law. So there are some interpretation of Article 21. First is Gopalan case 1950. Under it, protection under Article 21 available against arbitrary executive actions, but not against arbitrary legislative actions that follow procedure established by law. But under Menaka Gandhi case 1978, protection under Article 21 is applicable against arbitrary executive actions, but also against the arbitrary legislative actions that follow procedure established by law, and it must also follow due process of law. So, if we talk about the narrow meaning of Article 21, as it means liberty related to person or body of individual, but with respect to wider interpretation, it talks about variety of rights. They may include as so variety of rights may be as which are written here. You can read for your understanding as emergency medical aid, life insurance, against noise pollution, live with human dignity, privacy, etc. So next article is Article 22, protection against arrest and detention. As protection during arrest and detention, it comes into action after the arrest in certain cases, but it doesn't guarantee a fundamental right against arrest and detention, but it only provides a protection in case a person is arrested or detained. With respect to punitive detention, a punishment for a crime after trial and conviction by a court, and with respect to preventive detention, to prevent commissions of a future office offense. So these were the articles which I have discussed with you. So thank you for all and have a nice day.